Good morning, ladies and gentlemen. We're going to focus today on study unit 14, which focuses on civil unions. A civil union can be concluded by partners of the opposite sex or by partners of the same sex. It has been recognized that it has been recognized and came into operation in 2006. It is monogamous, voluntarily a union of two people, at least 18 years of age and solemnized and registered in accordance with the procedure prescribed by the Act. It includes a marriage and a partnership in terms of the Act. Kindly note that the civil union has similar requirements as to the civil marriage. The legal requirements for a civil marriage: 1, capacity to act. In order to be able to enter into a civil union, it does not offer an exception to the rule that any minor may enter into a civil marriage. Remember what we talked about in the previous study unit, in the first session, study unit 1, when we were focusing on legal requirements under the capacity to act. The issue of minor was raised, and the exception of the rule does apply also in this in the civil union. 2, there must be an agreement. The agreement must be between both parties themselves and must have the intention to enter into the civil marriage with each other. The same rule applied to agreement of the civil marriage applies to the agreement in respect of civil union. 3, lawfulness. One cannot be a party in a civil union where they are a party to a civil union or a civil marriage, meaning that you cannot be in a civil marriage and then enter into a civil union, or you cannot be into a civil marriage into a civil union and then enter into another civil union. Remember, we mentioned at the beginning of this session that a civil union is monogamous, which means it's between two persons. Prohibited degree of relationship also does apply under lawfulness. Remember what we mentioned on the congestionality of degree and the affinity of degree of relationship. It also applies in civil union. So we're going to go to the fourth requirement of a civil union, which is the prescribed formalities. Under prescribed formalities, there are certain factors that we are going to address, and I think there are 4. There's this marriage officer and the civil union ceremony, and the formalities during the civil union ceremony, and the registration of the civil union. So we're going to iron out the prescribed formalities of marriage officers. The marriage officer solemnization and registration of a civil union takes place in the same way as it is done in the civil marriage. We will need to go refer to our session in study unit 1. The appointment of a religious marriage officer differs from the civil marriage. For the civil union to be solemnized, the religious organization must apply in writing to the Minister of Home Affairs. Another factor under prescribed formalities. Formalities preceding the civil marriage union. The civil union ceremony. A person who wishes to raise an objection must be lodged by a written objection with the marriage officer who solemnized the civil union, which means the person who is against the marriage must approach the marriage officer in writing, which means he can write a letter to him with reasons why he's objecting to the solemnization of the civil union. And this must also be handed over at the civil ceremony. Identity documents or prescribed affidavits must be produced by both parties. Before the solemnization of the marriage, of the union, the marriage officer must ask both parties whether their union should be known as a marriage or a civil partnership. So whether you are going to call the union a civil marriage, a marriage or a partnership must also be mentioned at the ceremony. So we're going to go to the third factor under prescribed formalities, which are formalities during the civil union ceremony. The ceremony must take place in the presence of both parties and with at least 2 witnesses. Entering into a civil union by proxy is not allowed. Solemnization can be done at any day of the week between 8 a.m. and 4 p.m. Lastly, the registration of a civil union. The marriage officer must keep a record and issue each couple with a registration certificate which states that they entered into a civil or a marriage, a civil partnership or a marriage under the Civil Union Act. And he or she must send the civil union register to a regional or a district representative of the Department of Home Affairs. We're going to focus now on the consequences of a civil marriage. Remember, I did mention that some of the requirements are similar to those that were mentioned in the civil marriage. Here we're going to focus also on consequences of a civil union. Some of them are similar to the ones in the civil marriage. So we're going to also iron out those that are not similar or those that are not mentioned in the civil union, but in the civil marriage, pardon me, but are only in the civil union. So invariable consequences are similar to those under civil marriages. You can also see that in study unit 3 to 6. However, under the procreation in a civil union involves artificial fertilization, and in the case of a male couple, it involves surrogate motherhood too, which can also be also when there's a female couple, which will involve surrogate fatherhood. The dissolution of a civil marriage, of a civil union, the same rule provided in the civil marriage applies even in the civil union. So invariable consequences. In Section 13, subsection 1 of the Civil Union Act, the legal requirements of a civil marriage must be applied to a civil union with which changes as may be required by context. The application of a marriage indicating who the father presumption in a civil union between heterosexual person is easy as there is a male civil union partner who can be presumed to be the father of the child to which the female civil union partner gives birth. However, it is unclear if the same applies to same-sex civil union. In the case of the rules regarding artificial insemination, fertilization, and surrogate motherhood determines who the child's parents are in the case of a same-sex union, civil union. Application and adoption version of the marriage indicates who the father presumption in respect of such civil union is probably not viable. So I'm going to, there's a new case that came up, which was decided in the Constitutional Court. This case, it's also mentioned in your tutorial letter 201, but I'm just going to read it out for you so that you have an understanding of what's going on regarding the surrogacy and insemination, fertilization of same-sex partners. So in this case, the issue was the constitutionality of Section 40 of the Children's Act 38 of 2005 and the parental responsibility and rights of the same-sex couple in a civil union. The purpose of the study unit is study unit 19. And note that the decision of the High Court, this was from a decision of the High Court in EJ versus Hooked 2022, and it was recorded in the law report, which concerns Section 40 of the Children's Act. Section 40 regulates the position of children conceived through artificial insemination. The applicants, which were married spouses in a civil union, brought a court application on the basis of a Section 40, that Section 40 does not give automatic parental responsibility and rights to spouses in a civil union to a child born to the other spouse through an artificial insemination. So now the court did not agree with the applicants. The court held that although Section 40, subsection 3b uses the word husband, the section applies to all spouses. The court said that in order to prevent any common law obligation that arises between the sperm donor and the child, the legislation had to make provision that no right, responsibility, duty, or obligation arises between the child born through artificial insemination and the gamete donor, except when that person was the husband of such a woman at the time of the artificial insemination. The court further said that the purpose of this is to create legal certainty regarding the acquisition of parental responsibility and right in respect of a child born as a result of artificial insemination. The use of the word spouse in Section 40, subsection 1 indicates that the intention of the legislature to include same-sex female couples and therefore a spouse in a civil union automatically requires parental responsibility and rights of a child born of artificial insemination. So that is the case that was recently decided by the Constitutional Court regarding the constitutionality of Section 30 or 40 of the Child's Act and the standing of the parents of the same-sex couple in a civil union. Section 26, subsection 1 of the Birth and the Death Registration Act allows a woman to assume the surname of the man she is concluding such a marriage with. After her marriage, one resumes a surname she bore at prior any time. The widow or the divorced woman, and this also applies to the widow or the divorced woman, which means a widow can easily go back to the surname that she was using before she got married, and the divorced woman can also go back to use the surname that she was using before she got married. Section 1312 of the Civil Union Act states that reference to husband or wife in any act, in any marriage act or recognition of customary marriage act includes civil union partner. The difference between the position of civil union partners and spouses in civil marriage is unconstitutional because it constitutes unjustifiable inequality. The couple's matrimonial property system also applies if the civil union partners are of the opposite sex and the male partner is domiciled in South Africa. Problem arises if the civil union partners are of the same sex and one or both of them are not domiciled in South Africa. So this explains that issues that are not even resolved at this current point arises where civil partners, either one of the partner or both of the partners, are not domiciled in South Africa. So the dissolution of a civil marriage, this is similar to the civil marriage that we addressed in study unit 1. The same rules governing the dissolution of a civil marriage applies in a civil union. So in section 7, subsection 3 of the Divorce Act permits distribution of assets only if the parties are married before 1 November 1984 or 2 December 1988. The distribution of assets is not available to any divorcing civil union partners. So there's a restriction regarding the distribution of assets in a dissolution of civil union partners. So the Divorce Act states that the distribution of assets is not available to any divorcing civil union partners. Lastly, the constitutionality of the Civil Union Act. The legislature was required to afford same-sex partners the status, the benefits, and responsibilities accorded to opposite-sex partners or couples. The Act awards the same rights to both heterosexual and same-sex couples to enter into a fully recognized relationship and can be called a marriage or a civil partnership. There is a view that the act must be repealed because it unjustifiably violates the right to equality because some of its provisions apply to same-sex couples, confers a second-class marital status on same-sex couples, and produces new forms of oppression and reputation. That concludes the end of our session, study unit 14 on civil unions. I hope that was clear. All the best with your exam preparations. Thank you very much.